Well, good evening, everyone. Welcome to the Parsons Centre Law and Business webinar series. My name is Jason Harris. I'm Professor of Corporate Law at Sydney Law School. And this is a webinar series that we've been running for many years. We traditionally ran these webinars as seminars in downtown Sydney, but since March last year, we've been running them as webinars. And one of the great things about doing them as webinars is that we're able to reach a much broader audience. We're also able to attract speakers from interstate. Our speakers tonight are Eddie Griffith and Nick Cooper, and I'll go through their bios in just a moment. The topic that we're going to be discussing tonight is an incredibly important topic, both now and also in the near term. And it's the topic of the new small business debtor in possession regime. Can it be made to work? This is a topic that we covered in several webinars last year, actually, towards the end of the year. Many of you who are on the line might be aware that the federal government introduced some reforms into the Corporations Act that commenced on 1 January this year by inserting a new part, which is Part 5.3B of the Corps Act. For those who are involved in insolvency, you'd know that we already have Part 5.3A of the Corporations Act, which is the voluntary administration regime. So the new regime, what we're calling the new small business debtor in possession regime, is meant to be something that is different from the voluntary administration regime. So we're going to be going through and having some discussions about what the experience on the ground with the new 5.3B has been over the first 10 months of the year. And I'm delighted that we've got our discussion panel tonight. We've got Eddie Griffith, who's a partner and turnaround practitioner at ReGroup Solutions in Adelaide. Eddie's got over 20 years experience in business recovery, insolvency and turnaround management, both here in Australia and also previously in the UK. He's worked with both large enterprises in formal insolvency and turnaround engagements, and more recently with small and micro businesses. Eddie's also the founder and the chairman of the Association for Business Restructuring and Turnaround, which is known as ABRT. And you can find some information on the ABRT website about their membership and educational program. We've also got Nick Cooper. Nick is a managing partner at Oracle Insolvency Solutions in Adelaide. And he's a chartered accountant and a registered company liquidator, and also a trustee in bankruptcy for personal insolvency. He's got over 25 years experience in insolvency, both at the small and the large end of town. And recently he was appointed in one of the first small business restructuring appointments that is under the new Part 5.3B, which is in respect of a fine dining establishment in Adelaide known as Martini on the Parade. So I'm just delighted that we're going to be able to hear how the new small business restructuring regime is actually working from people who've been involved in both in terms of its formulation in the lead up to the introduction of the regime, and also people who've been involved in taking the appointments. So before we get started, I will stop sharing the screen. And just in terms of logistics, so this session is being recorded. A copy of the recording will be posted up on the Sydney Law School YouTube page and also on our events page. You can actually find the back catalogue of our webinar series that we started in March last year if you go to the Sydney Law School events page and have a look at the podcast link that we have on the page. So we've done a number of insolvency and restructuring webinars over the last 18 months, including, as I said, one last year where we had Eddie and also Brett Kedgerina from Hall Chadwick talking about the proposal for a small business restructuring procedure. So it's fantastic that we're able to kind of close the loop and come back just over a year later to then talk about how it's actually been implemented and how it's working. If you do have any questions for our presenters during the session, there is a Q&A button that you should be able to find on your toolbar there. And if you'd like to post up your question, then we'll get to the questions towards the end of the session. That's probably it in terms of the logistics. So we'll make sure that we finish up by 7 o'clock. Thanks everyone for giving up their time. To start off, before I throw over to our presenters, I guess from my perspective, it's been really interesting to see how this new regime has been introduced into Australian insolvency law. One of the things that I've been writing about for some time, I can recall writing a book chapter back in 2014 advocating for the need for a small business voluntary administration type regime. So it's something I've been interested in for a long time. It's been really interesting to see how the idea has come about that, maybe we do need a small business tool to try and deal with the problems of financial distress. And of course, it was introduced towards the end of last year, at first as an idea, when we were all still grappling with what COVID was going to mean for the future of businesses and their finances. Of course, in the middle of the variety of government support mechanisms and financial supports from the banking and finance industry and various other support mechanisms were put in place. And I guess we all would have hoped that we would have been past that by now. We're still, of course, grappling with that. We've seen over the last 2 years the numbers of formal insolvencies at all levels, not just the small business level, but the numbers of formal corporate insolvencies have halved in some categories, particularly around court liquidations. And yet, for any of us who've been able to walk down our local high street, one of the things that we will all notice is the empty shops that have been for lease for a long time, or the stores where you see the big pile of letters sitting at the front of the door. So even though we're not seeing large numbers of companies going into formal insolvency, it's clear that an awful lot of businesses and an awful lot of small businesses are really doing it tough financially. And we suspect that perhaps many of those have indeed collapsed, and maybe we've seen the owners just walking away from those businesses. So the idea is that there clearly is a problem there. We need an effective tool that is going to actually be useful for small business, because we already have a variety of other procedures, liquidation, voluntary administration, receivership, etc., that can be used. But small business provides its own unique dynamics. That the nature of small business, the nature of their asset base, the nature of their financial problems really requires its own approach, and maybe having a full voluntary administration or a full liquidation isn't always going to get us the best commercial outcome or the best commercial use of those assets. To a large extent, that's what we discussed last year, Eddie, in terms of what are the challenges for small businesses. So that's, I guess, the background of the introduction of Part 5.3b. We had the Treasury Department, which announced the discussion paper last year with the draft laws. There was some fairly rapid consultation with the insolvency industry and the legal industry and the finance industry. And then we had the final version of the law passed towards the end of the year, including the voluminous regulations, the 40, 50 pages of regulations that we see for Part 5.3b, all of which commenced on the 1st of January this year. So one of the things that I think is interesting looking at, just from my perspective as an external observer of these things, is having a look at the numbers of appointments that we've seen in now the first 10 months of the small business restructuring procedure. And I actually just did a search of the Insolvency Notices website, which is maintained by ASIC, about 20 minutes ago. And what we've had in the first 10 months of this year is we've had 20 companies that have entered the small business restructuring procedure under Part 5.3b, at least in terms of 20 companies that have a notice of the appointment of a restructuring practitioner. And of those 20 companies, we've had 13 companies which have registered that a practitioner has been appointed in respect of a restructuring plan. So for those of you who might not be working in insolvency, to give a very short overview of how the small business restructuring procedure works, typically in a corporate insolvency situation, you have the appointment of an external administrator. So that's someone who's a registered company liquidator, someone like Nick, or someone like Eddie in his former life as a registered company liquidator, who will basically take over the management of the company. And they will have various statutory obligations that they need to perform. They'll do some investigations. In some types of procedures, they might have reporting obligations to creditors. They might need to convene meetings of creditors to advise them of what's going on. There'll be kind of regular letters going out to creditors, emails to creditors, informing them of the process. And I guess the challenge for a lot of small businesses is, that procedure, which is being managed by a highly qualified and heavily regulated professional often with more than 10 years experience in the industry, that's not a free process. It's not a cheap process. There's various things that have to be done by law. And many of these businesses that get to the stage of needing an insolvency practitioner actually have very low asset bases. So if you've got a business that's, there's literally no money in the bank, there's very little by way of tangible assets, there's maybe some book debts that can be recovered and not a lot more. It's that the existing insolvency procedures pose a challenge for those types of companies. And so I guess the government's views on why we needed a small business restructuring procedure was, well, maybe if we make it what's called debtor in possession, which is different from the other types of corporate insolvency, which are external administration, an independent person coming in to take over and manage the business. If we keep the existing management in place, if we keep them running the business rather than an external registered company liquidator, then that might help address some of the cost concerns, because they're the ones who are going to be conducting the day-to-day affairs of the company. Now, if you're advising creditors or if you're a creditor yourself, you might be concerned, well, is it perhaps the fault of the directors that the company's gotten into this situation, and should we really be leaving them in control? There is still a highly qualified insolvency practitioner who's a registered company liquidator who is appointed as what we call a restructuring practitioner. And they're there basically to assist the debtor company's management to go make their way through the process, to prepare certain documents to be distributed to creditors, and to conduct, ultimately, if a restructuring plan is put forward, to manage that voting process with the creditors. And they would then typically become the restructuring practitioner in respect of the restructuring plan for that particular company. So it's not as if the directors, if you like, are just getting a free kick and they don't have to pay their debts and they can string creditors along. There is still an insolvency practitioner who's there, who's monitoring what's going on. They have the power to terminate the procedure if they think that it's not being used appropriately or it's not in the creditor's interest. And of course, we've also got the court there having its general supervisory jurisdiction. We do, of course, have somewhat similar procedures in other jurisdictions. Singapore, for example, India have recently introduced specific small business regimes. England for a long time has had the company voluntary arrangement procedure. And of course, even in the United States, we hear a lot about the Chapter 11 bankruptcy and restructuring procedure. Last year introduced a small business Chapter 11 procedure, which is in their subchapter 5 of the bankruptcy code. The World Bank, a number of years ago in 2017, produced a large report noting that really insolvency laws need to have a small business alternative because the standard insolvency procedures are often just too complex, too lengthy, and too expensive for many small businesses. So certainly the idea that we need a small business alternative in these scenarios is not a new one. And personally, I think it's good that we've acknowledged that in Australian law. I myself have some reservations about the form that we've acknowledged that in terms of Part 5.3b. And so I'm really keen to hear from our speakers tonight. So that's just an overview of how the procedure works. And as I say, if you've got any questions as we're going along, then we're happy to deal with those at the end. So Eddie, if I can start with you, what's been your experience with the introduction of Part 5.3b?
Well, my first thought was that it would be similar to the CVA, the UK CVA, and there seemed to be quite a few similarities. The small company CVA wasn't a big uptake in the UK. But at the time, that was around the administration, pre-pack administration came about, and so it seemed to it just seemed more complicated at the time, so didn't get a lot of uptake. But what I found is that people are people are interested in the term debtor in possession. So, that particular term has been attractive to accountants and directors. So they're interested in potentially being able to put their hand up, say they're in trouble, but still not lose control of their business. And then there is the fact that they can. There is a moratorium there. There's some protection there for the directors against enforcement of personal guarantees, and that to me, again, not dissimilar to the way safe harbour was it's quite a nice term. It's gentler than liquidation or voluntary administration. It sort of brings people and directors in front of you, gets accountants and directors talking to you about what their potential options are. And one of those options, obviously, is now 5.3b. Unfortunately, when we dive then into it, though, and we go through some of the details, we find that it's quite difficult to access. I had a query from someone via an accountant. They were undertaking an organisational restructure, getting rid of some unnecessary staff, pivoting the business, I think they call it now, due to COVID reasons. And they had created entitlements, employee entitlements, by virtue of making these redundancies. And so when they then called me back up again and said, so now can we go ahead? I had to sort of point out they then weren't eligible, because obviously all entitlements need to have been paid. So it's quite difficult to communicate to directors and to accountants sometimes, just how complex an area this is. But yeah, it's been given, it's called debtor in possession. It has a nice ring to it. And I would argue that it's probably, it sounds better than it actually is.
And the debtor in possession model is, of course, not new around the world. As I was saying a little earlier, if we look to the Chapter 11 model in the United States, that's, even though they're both debtor in possession, that's really a different universe from what we're talking about here. In Chapter 11, which gets talked about so much in the media, about that being a potential model for Australia, really is an entire ecosystem. You've got specialist bankruptcy courts in the United States. You've got specialist judges that basically that's all they do. If you go down to the Southern District of New York or something like that, you've got judges who are dealing with Chapter 11 cases day in and day out. And really those bankruptcy courts, they're not courts in the sense that we think of kind of Chapter 3 of the Constitution courts, judges appointed completely independent and, appointed basically until they reach the mandated retirement age of 70. They're kind of more limited term appointments. They're more practitioners who get appointed as judges there. There are quite a lot of academics as well who are appointed as bankruptcy judges in the US. But, in our system, we don't have that. And that's not in any way a criticism about courts, but our courts are not there to basically hold the hand of directors as they're going through a debtor in possession regime. Our courts are there to determine legal questions. Can a liquidator do this? Can the company do that? Has the contract been contravened or something? That's really a different role than what we see in the US style of debtor in possession. But the company voluntary arrangement regime that exists in England, Eddie, I find quite interesting, in that it is debtor in possession in the sense that you don't have an insolvency practitioner who's running the whole business, that they're really there to help guide the director, formulate the CVA proposal and to conduct the meeting and also report to the court if that's needed and terminate the procedure if that's needed. So, recognizing that external administration isn't always the best answer. That if we want to preserve the business, to preserve that enterprise value and really to protect the goodwill so that we're not sending the message to all the stakeholders, this is a failed enterprise. Don't expect ordinary trading conditions because this duck has been cooked, as it were, which is what practitioners and business advisors tell me is often the message that goes out if you say, well, a voluntary administrator has been appointed, or the company's gone into liquidation, or the company's gone into receivership. Everyone assumes, or many people assume, that, well, that means the company's done and dusted, it's gone. And of course, that has an adverse effect on expected values. If you then want to put some money into the business and turn it around and whatever, you want to buy the business and recapitalize it, maybe the expectation is, well, this business really is dead and I can get it on the cheap. And that provides the frame of reference. Whereas if what we're trying to do here is change that reference point so that it isn't a failure, the business has financial difficulty, and the purpose of going into this small business restructuring regime is to try and address those problems. It's not simply to put the notch on the tombstone, as it were.
Yeah, and that's one of the major problems you've stated. As soon as external administration is written across ASIC on the search, then it pretty much means that business has had it. The media just don't differentiate between the various insolvency regimes. There are some lenders now who are sort of taking advantage of this, sort of coming out the woodwork and saying, we'll put our hand up, we'll actually help fund this. BizCap springs to mind, but they're actually trying to use this opportunity to sort of second-tier lenders leverage position and support sort of small business restructuring. For want of a better regime at the moment, I think the expectation was Treasury said that this was going to be solving at about 70%. Is that right? Of the problems that COVID was going to be bringing about. It's not even been close. Yeah. And you've got to really just think about where the other leaks are. And one of the major leaks I'm coming across all the time at the moment is deregistration or do nothing. Yep. Quite literally, we don't have to do anything straight away. The ATO pressure isn't there. And so the advice, professional advice as well, is that I'll just leave it for now. We'll figure it out. You never know whether, what's around the corner with the economy at the moment. So let's just zombify it.
Yeah, I mean, on the deregistrations, one of the great things about being an academic is we have a bit of time to look into things, and I actually had a look on the ASIC Insolvency Notices website, and when you do a search for different types of notices, you can look at historical data as well. And so I did that for deregistration notices. And it does allow you to go right back to August 2012, which is when that particular website started. And I had a look at all of the ASIC deregistrations and all of the voluntary deregistrations. Now, that required me to click through a great number of pages because it will only list 10, I think, at a time, or 20 at a time. But I worked out that on average, because I'd managed to get to the last page and saw the total number and then divided it by 8.5 odd years. On average, since 2012, we've had about 53,000 companies go through an ASIC-initiated deregistration every year. Now, why are they going through an ASIC-initiated deregistration? It could be that they've been abandoned. They're not responding to ASIC's inquiries. They're not filing their notices of particulars and paying their fees and the like. That could be a lot of them. There could be other reasons. We don't know. And to a certain extent, that's part of the problem, is we don't know. We don't have any detailed figures produced by ASIC as to why companies are being deregistered. All we know is the raw number. My concern is that we may well have some companies that are engaging in improper Phoenix activity, and they're basically assuming, well, we'll just do nothing, and nothing to see here. And I guess if anything happens to it, it just gets deregistered. And if no creditor complains to ASIC about it, then it just gets deregistered and everyone just moves on. And you know, I'm concerned about that I think we should have a process that at least looks at some of those companies, because I'm not convinced that any of them get looked at the moment. I think it's a model where, you know, ASIC takes an action, posts in the Gazette. Does anyone have any concerns? Oh, well, no one has any concerns. Well, we'll just deregister it. And, you know, Michael Murray, for example, my co-author, has said for a long time, well, if it's a system that really is focused on trying to act in the creditor's best interest, and you're telling creditors, hey, we're going to do this. If you've got a problem with it, let us know, and no creditor responds, well, maybe it isn't a problem. I think it's a problem in terms of respect for the rule of law, and, you know, there should be some degree of transparency about that. Now,
I think once they actually plug up that gap, though, then the next error, or sorry, I suppose the next problem you're going to encounter is it's the too poor to go broke. But at least you'll be forcing them towards advisors. You have to do something about that company. You can't just abandon it. So at least then we'll know what we're dealing with. You know, and I know that you've talked a fair bit about having the official receiver type role over here.
Yep.
But yeah, certainly from where I'm sitting at the moment, they've got to plug that gap with deregistrations, without doubt.
Yep. Nick, I'd like to bring you in at this point. What's been your experience with the new small business restructuring regime so far?
Yes, well, as you mentioned earlier, we've successfully done one small business restructure, which was one of the 20 you mentioned. In fact, it was one of the 13 that they put forward a plan to the creditors, and it was accepted. So it achieved its purpose, so to speak, but not without a few hiccups along the way. One thing I'd probably first like to focus on is the amount of time we had to spend with the directors pre-appointment was rather significant. Also, we need to explain the process. It was a new process, how it all works and what their obligations were, explaining about getting their tax lodgements up to date by the time that the plan is presented to creditors. So that required a bit of planning by the company and the accountants to get everything up to date. And also employee entitlements, having the company being in a position to pay those entitlements when they're due. So there's a fair bit of planning involved. Another thing which arose just before we appointed is the status of the company's insurances. There was some question that many insurance policies have a trigger in the event of an insolvency. So the company's insurance broker had to make sure that there was no such triggers in the company's policy, so that would void their insurance once we're appointed. So that's one thing they had to get in line. But just in terms of the eligibility criteria, in terms of ATO lodgements being up to date at the time the plan is presented, they made sure that the tax returns and the activity statements were up to date and were lodged, and that was fine. However, when we were appointed, there was a small hiccup in that the ATO, and quite reasonably, I should suggest, did require a part year or a part period activity statement to be prepared. So from the beginning of the last quarter to the date of appointment, they needed a part period activity statement prepared. So that was one thing which the company had to cope with at the last minute. But fortunately, they did do that, and the ATO managed to ascertain exactly what its debt was, which was good.
So, Nick, can I just ask a question about that engagement? So,
yes.
Can I ask, why was that selected rather than, say, a voluntary administration or a liquidation? Was there something about 5.3b that was particularly attractive for the directors?
It was. I mean, this was your classic small business. So it was a family-owned and operated restaurant. Didn't have a lot of assets. And just from the cost point of view, a voluntary administration, it was a trading business, and this was a restaurant that was trading throughout the process in the control of the director, and is still trading. To have a administrator appointed, there would have been that additional cost of the trading operations being supervised by the insolvency practitioner. So there was a cost saving there.
Yeah. Okay. And so you had to basically explain what this new procedure was going to do and how it was going to work. I guess that would have been a challenge, given that it was all introduced fairly quickly. There's, not much regulatory guidance about how it operates. You know, there's people like me and Eddie and others who are writing posts on LinkedIn about how we think it's going to operate. I mean, how was that process explaining it to the directors?
Yes, it was challenging. It was, in fact, it was a learning process for us as we entered the regime and went through it ourselves. So we had to get our own advice on how it would work and what our obligations were. So again, a fair bit of planning from our own point of view before we then explained it to the directors. So that was quite time consuming. But once we were appointed and things were underway, as I said, there were a few hiccups along the way, but the process itself was fairly smooth. One thing I should mention is that many creditors, and in fact banks as well, didn't quite appreciate the nuances of the new provision. In fact, the first challenge we met was on the day of our appointment when we sent a notice to the company's bank advising of our appointment and saw confirmation of what was in cash at bank position. We stressed in bold, big underlined letters, do not freeze the bank account. We're not asking you to do that, but of course, the bank froze the bank account. That's what they normally do when they receive a letter from a insolvency practitioner. And that was a problem for the directors because their pay run was due that day, so they couldn't pay their employees, and it took a couple days, in fact, for the bank to sort that out. So it was a big hiccup to start with, but we got through that, and then the trading operations during the process actually went fairly smoothly. We did actually expect some suppliers to have some concerns and not grant credit to the company during the trading period. Surprisingly, though, I think virtually all the suppliers did grant credit to allow the company to continue trading. And it's probably mainly because it was a restaurant, and the trade suppliers in particular were food and beverage suppliers of relatively small debts, and also hadn't been were more or less kept up to date prior to the appointment. So they were supportive of the company and they did grant credit. So that was an issue in our administration. But I certainly can see it would be an issue for other trading entities with large commercial suppliers.
So we've had one question, which is from David, and he's asked, how do you justify taking on so much risk as the restructuring practitioner relative to the level of likely compensation? Were you concerned about the potential risks involved? And, bearing in mind, and this is going a little bit into the weeds in terms of how it works, but for those on the line, basically the restructuring practitioner has a legal obligation to, it's not a certification, but it's basically, and it's not even really a report to creditors, but it's giving their opinion about certain things with the restructuring plan and their eligibility for the company to use it based on the information that the directors have provided to them. And the wording of the legislation actually says, if you as the restructuring practitioner don't have reasonable grounds to make those statements to the creditors, I mean, that's a criminal offence potentially. So that was certainly something I was concerned about. And I jumped up and down before it was introduced saying, why do we need this? Why are you hanging the sword of Damocles over the insolvency practitioner for this new procedure? So, I mean, maybe you could talk a little bit about that. What were your thoughts about the potential risks? A brand new procedure, presumably no one else in your firm had ever done one. Very few people have actually done one. How did you manage that?
We certainly managed that risk by getting some pretty certain legal advice as we went through it. I guess in terms of risk, it is a different risk to a voluntary administration. What we didn't have was the trading risk of a business that we're responsible for the debts, and if things go pear-shaped, that we're personally liable for the debt. So fortunately, we didn't have the risk of a personal liability in the trading administration. So that was to the process of credit, that we don't have that risk. But you're right in saying that there is a risk that if we don't follow the procedures, there could be a severe penalty, or, as you say, a criminal sanction if we make a declaration which is not correct. Having said that, the declaration that we had to make was fairly confined. The main contentious issue there is whether the company is likely to be able to meet its obligations under the plan. And if the plan was such where there was payments from trading receipts, that would involve a fair bit of commercial judgment as to whether the company can continue to make it. In our particular case, it was a payment of a lump sum, and that lump sum was sitting in a trust account, basically, involved by the directors. And it was there, we could see it. So there was no difficulty we had in giving that declaration that the amount was there or was likely to be able to be provided to creditors. And in fact, it was. So the risk in this particular administration wasn't huge, but we were mindful that, and we had noticed some early administrations which did have to go to court for various directions. So it was a risk, but not as substantial.
Did you have any concerns about your own professional indemnity insurance? I've heard from some insolvency practitioners here in Sydney that they're a bit concerned about how their insurers are going to view this new procedure.
That's a good point. We didn't have any specific concerns. We do obviously have a fairly expansive PI insurance policy, which does cover all our roles in capacities as insolvency practitioners, which is defined. So we didn't have any reason to believe that wouldn't extend to this type of appointment. So that it was something we turned our mind to, but we weren't too concerned about that.
Okay, so the definition of insolvency practitioner in your policy covered this new procedure?
Well, in fact, it did cover specific administrations plus any other roles as an insolvency practitioner. So we were comfortable that our role was within the field of insolvency practitioner.
Okay, great. And how did you find like aside from the suppliers, was the ATO a major creditor in this company?
It was certainly it was a major creditor, but not the most significant creditor. Was less than 50% in value of the votes. And I should say that the ATO did not vote in favour of the plan. Nonetheless, the majority did vote in favour, so it was accepted. And one thing we did note, and I think it has been made publicly available, that the ATO have got an expectation as to the information that will be provided with, which is not dissimilar to a voluntary administration. Right. So whilst the minimum requirements to be provided to creditors at the time of presenting the plan is fairly basic, the ATO expected a summary of the historical financial information, including balance sheets, budgeted protected information, and also a hypothetical return to creditors in a liquidation scenario. Yeah. Which in our administration we didn't provide, and we were asked to do that by the ATO. And accordingly, they decided not to vote in favour of it. But it's something to bear in mind in future, that if the ATO was a significant creditor that affect the outcome, that's the type of information that they'll be looking for. Yeah. Which of course requires the practitioner to do a lot more work than the minimum required by the legislation.
Yeah.
Can I ask a question?
Yes.
Debtor in possession. So effectively, the directors are permitted to operate the business in the ordinary course of business. They're allowed to carry on. Did you have to deal with many questions about disposals? Did you have to give many authorities, or because it was a restaurant, was that quite easy? There was nothing really to sell in terms of assets.
That's right, because as many will be aware, the restructuring practitioner does get involved if there's a proposal to sell an asset outside the ordinary course of business, in which case written permission from the practitioner is required. In our case, we didn't receive any requests from the directors. It was, as I said, it was a restaurant, and it was just the normal day-to-day trade. So we didn't need to get actively involved too much with the running of the restaurant business. Having said that, I should mention that some of the creditors didn't appreciate the debtor in possession model, and of course looked to us to pay the accounts and to sign credit applications and so forth. So we had to politely explain the process that we're not liable for these debts, not responsible for these debts. So again, a bit more of an education requirement on our part. But as I said, the company's director was able to obtain credit during the period of the restructuring appointment, so that wasn't an issue.
So we do have a question from the audience, Nick. Yes. This is a question from Jill, and she asks, what level of investigations did you undertake compared to other options such as voluntary administration?
Yes, well, we certainly did investigate the position of the asset. So whilst there's not a strict obligation to work out what a likely dividend would be in a liquidation scenario, we certainly did satisfy ourselves that what was being offered in terms of the plan was a better return to creditors. So we did do basic investigations into the state of the assets, without doing the same level of detail that we would do in a voluntary administration.
We've also got a question from Taylene, who asks, was there a secured bank that you needed to negotiate with?
In this case, no, there was no significant secured creditor. So it would have been interesting if there was, and to see what their attitude would have been to it. But that wasn't an issue for our administration.
And then Michael has asked, to what extent were personal guarantees of the directors involved? Or would they typically be involved, and how would they? So in this case, to what extent were personal guarantees of the directors involved?
Certainly, we were aware that some of the trade suppliers did have personal guarantees. So whilst they would receive their distribution under the plan, they could obviously hold the director account for the balance under the personal guarantee. So that was something which the directors were mindful of, and we advised that it's something they will need to address down the track, regardless of the outcome of the administration. That was certainly the case, that there were personal guarantees, and I guess that's an interesting thing as to how that affected their vote. If they're going to receive a payment from the plan and a balance from the directors under the personal guarantee, I guess that they've got no reason to vote against the plan, because they're going to get paid one way or the other, particularly where the company's continuing in business and trading.
Yeah. So I guess what I'm picking up here is, this, as you say, it's a small family business. And I'm guessing that the directors and the managers probably had some quite long-standing relationships with, key suppliers who are supplying them with produce and the like. And it's really about, that stakeholder engagement. One of the and keeping your key creditors informed of the process and what it involves, so that they keep that confidence. One of the concerns at the start, and I was writing about this on LinkedIn earlier in the year, was really worried about the trade creditors, because you do have, as you said, that this different model that with a voluntary administration, you can stand up as the VA at the first creditors meeting and say it's business as usual, because all your invoices that I'm authorising are going to get paid because it's coming out. I'm on the hook for that liability, and we don't say that here because it's not external administration. Instead, are in possession. But if you've got basically a good business with good relationships with your customers and good relationships with your key creditors and your suppliers, then they, more often than not, they will support you if you're coming up with a restructuring plan. So can I ask, what was involved in the restructuring plan?
So the plan itself was a lump sum contribution, and it's public knowledge, so I can say it was $100,000 that was put up by the directors. They had that money set aside. It was there to be put in as soon as the plan was accepted. It was, I guess, made the administration simplistic. If it was a contribution from trading receipts, that would be a whole different story. That would involve monitoring, and also for the restructuring practitioners to assess whether the company would likely to actually be able to meet those contribution payments. So because it was a fairly straightforward, clean-cut, here's the money, it's on the table, accept it or not, the job for us was quite straightforward. Having said that, we did encounter one small hiccup when the plan was accepted. So just to reiterate, we're now at the stage where the plan was accepted. The $100,000 contribution has been paid into the account under our control, and we're just about to process the dividend checks. We did encounter one little, another little hiccup with the not the ATO, but just in terms of the GST impact. As some of the audience might be familiar with, in a liquidation or a deed of company arrangement, there's a GST adjustment required where a company's been accounting for GST on an accruals basis. And that was brought in after GST came into effect, because the ATO was losing out effectively, because the company would claim GST credits but not pay those debts, because the liquidations of deeds of company arrangement hasn't been amended from our research to include small business restructures and these plans. So it's a question mark as to whether we need to go to the ATO and say that we're about to pay a dividend. Here's our calculations on a GST adjustment. Would you like to increase your proof of debt? The legislation hasn't changed since the SPRs came in, so it's unclear as to whether, and there isn't a catch-all definition in the GST legislation as to whether it applies to SPRs or not. So that is something we're still trying to work through with the ATO at the moment.
So we've also got a question here from Tony, who asks, did any of the creditors refuse to supply except on cash on delivery terms, or otherwise modify their terms of trade once they appreciated that it was a restructuring practitioner and that you weren't responsible for the debts?
Well, certainly initially they did. So initially that was certainly the query that we'd received from our office, was the supplier say, okay, please sign here to guarantee this account. So we had to explain to them the way the process works. Ultimately, we're not aware of any of the suppliers who actually refused to deal with the company other than on a cash on delivery basis. Right. There may have been one or two, but as we're not actually involved in trading the company, that information just didn't come across our desk. But as far as we're aware, the trading operation, once everything was explained to the suppliers, ran very smoothly.
We've also got a question from Eddie in the audience, not Eddie on the panel, asking just about in terms of the overall cost. I don't know if you want to share what the overall cost was, but I guess I might reframe the question by saying, how does this compare with the overall cost of an administration? You noted that it was a trade-on, and so if it was a trade-on administration, I'm assuming, would that be kind of $40,000, $50,000, maybe more? So was this less than that?
Yes, it was. In fact, I'm happy to share those figures. So overall, the cost that we effectively charged was roughly $20,000 plus GST. So effectively $15,000 plus GST for the procedure, and then the balance, which was a percentage of the contributions paid to creditors, was to come out of the plan. It certainly would have been double that had we, or at least double that, had we been trading the restaurant as well. So I guess from the point of view of a return to creditors, the costs were less, and therefore there was more money in the creditors' hands. So that is a good outcome. From our point of view, though, the costs, because we obviously keep a time record of what our costs were in dealing with it, and that obviously did exceed the amounts that we charge as a fixed amount, as we're required to do. But then again, it was the first one, so you would expect that if we do a few more, maybe we'd be a little bit more efficient and perhaps see a better commercial outcome for everyone concerned.
So I've got a question from Lindsay here, which is for both of you. And that question is, how many approaches have you had for restructuring which you've had to advise against because the debts have exceeded $1 million or because the business can't bring the employee entitlements up to date?
I think it's accepted now, isn't it, that in terms of liabilities, the secured creditor, you only allow the unsecured portion of their debt towards that 1 million. I think that's, but that's not really been the main issue. The main issues being the up-to-date taxation lodgements, outstanding superannuation, and when I meet with a distressed client and we go through, I call it that business viability review type process, which is effectively where you start looking at it. You look at a quick ratio, liquidity gap, then look a bit deeper, understand the nature of the business, and then obviously if it requires insolvency tools, then you get onto that level. I'd say there's been a lot of inquiries, over 10 to 15 maybe, where they've phoned up actually asking about the debtor, this new debtor in possession type restructuring regime, and they haven't been eligible because of the tax office issues. So yeah, it's sort of been really more for me, yeah, between 10 and 15, but there's probably more than that, because you'll give some information to a director, they'll go away, do some homework, then they'll come back and say, well, you never told me about this new regime I could do. And you say, well, that's because it's highly inappropriate given your situation.
Yep.
So difficult to keep count, because these are a lot of micro businesses that are suffering. So these are inquiries that don't always tend to become jobs.
How about you, Nick?
Yes, well, likewise, similar to Eddie, that we do find that it's the eligibility criteria that get many of them come unstuck on. Often they'll come to us and say, yes, but we do pay our employees on time, and they don't have huge entitlements accruing. And then when you ask about superannuation, then it's, oh yes, sure, we've paid the recent superannuation, but yes, it's still owing from a couple of years ago when we had a problem. So it is the in particular the superannuation, which can mean a lot of people aren't eligible. Another interesting one which we did have fairly recently was in fact the largest creditor was the shareholders, so a related party debt. And of course, under this new regime, shareholders or related parties aren't eligible to vote in the process. So if they put a plan together, being in this case it was the largest creditor, but even if they were a significant creditor, they don't get a chance to vote on it. Whereas they do under voluntary administration. So for that particular company, voluntary administration was probably better for them than the sort of restructured process, because the related parties do get a say where they don't under this process.
Yep. So we've got a question from GB who asks about, I guess, your ability and comfort level in relying on information provided by the directors. So their question is, I guess, what checks and balances are in place to prevent the directors giving you incorrect information?
Yes, I mean, I guess that it's a problem with all forms of administration, whether it's be a voluntary administration or liquidation or a SBR. You can only rely upon the information you do receive from the directors. You can also verify certain information from the accountant. Most of the information that tends to be relevant is the quantum of creditors. If the creditors' figures are significantly different to what the directors have told you, then that could have a few implications. One, that the company could be ineligible for the process, so you need to terminate the process. Also, that could affect the return. So you base your report and your calculations on the creditors as advised by the director. And if they're incorrect, then that can substantially change the estimated return to creditors. So that is one very important part of the information that you need. You must ensure is correct. But also the creditors do get a say. So if they get the information given to them, and if they dispute their debts, they're entitled to come back and point out why the amount was wrong.
And did you have any creditor disputes about that schedule of debts?
We did. So we had a number of amounts which were different, but not materially different to what the director had said. In many cases, that was because the suppliers had included invoices which were post-appointment on their debts. So we had to explain that they had to draw a line in the sand and just work out the debt at the time for our appointment. So in that case, the creditors did amend did agree with the amount that the director had stated. I think there's one or two which were incorrect, which we agreed upon and allowed the creditors to amend their claims. And of course, the other one was the ATO debt. So the company and the company's accountant thought they had the ATO debt correct, but once the part period activity statement was lodged, then there was obviously an additional debt that needed to be included. So so that was fine for the ATO to amend its claim to include that additional debt.
So do we think the $1 million threshold is too low? Should that be raised? And to put it into context, I mentioned the Small Business Chapter 11 earlier. The threshold in the Small Business Chapter 11 is usually $2.5 million. It was increased to $7.5 million last year because of COVID. So do you think that the $1 million threshold is too low? From what I'm gathering, what you said earlier, Eddie, in your experience at least, it's not so much the $1 million liability, it's the other disqualifications in terms of the tax lodgement. So do you have a view about that $1 million? Should that be increased?
Well, I would love to know. I mean, there's so many different ways in which people, different departments, people actually measure what a small business is in Australia. I'd love to know the basis upon which they came about that $1 million liability figure. I mean, is it too low? It's hard to say. A company with $1 million worth of liabilities could also have, many billions worth of assets. I don't know is the answer. I don't think enough is. I think it's a nice safe figure. It's a nice safe round sum figure, and I'd love to know if any thought went behind what the calculations were to sort of come up with that amount. But I like you say, the bigger problem, as far as I'm concerned, is the superannuation. That's the real roadblock here.
Yes, yeah. From my point of view, I think that the $1 million figure is good, and if it was increased to $2 or $3 million, then perhaps small companies would be eligible to go through the process. My concern, though, would be for a larger scale company with that sort of debts, they probably are more reliant upon their suppliers for credit. And under the debtor in possession model, if we're dealing with a lot bigger amounts, a lot bigger trade suppliers, it would be, I guess, more likely those suppliers would say, thanks, but I won't deal with you on a credit term given what's happened. So I think the larger companies, if they went through the process, might come a little bit unstuck and not be able to trade because they can't get credit. Whereas we're dealing with a lot smaller suppliers, there's less money at stake, and that's less of an issue.
Yeah. So we've got two questions which are kind of overlapping, so I'll treat them as one question. This is questions from Carl and questions from Jill. And basically what both of the questions are saying or asking is, there's been a lot of concern about the kind of negative attitudes towards insolvency, that, it's our insolvency system is more about attributing blame than it is about actually dealing with the economic problems. In your experience and your views on this new procedure, do you think that is going to change the dialogue? Is this going to give us a new frame of reference where it actually is about trying to help business and help, right the business, rather than just, who's broken the law and who do we need to report on and who needs to be reported to ASIC? What's your view on that? Is this going to move the dial and change our attitudes?
Well, from my point of view, we've got a long way to go, but I mean, the question of this this actual webinar is, is there potential for 5.3b? And perhaps Nick's example is that there is potential. It's just that it sounds like there's a lot of work to do beforehand. I almost think of it like that nominee style work that you do in a CVA in the UK. I feel, almost that, there's a lot of heavy lifting there, a lot of education. But if we are able to get the right results that Nick's getting, then I think over time, perhaps maybe there is hope.
Yes.
Nick?
Yeah, I certainly agree. It certainly did work in the case that we're involved with. In fact, just to add to that is one thing we did notice, that there was a lot of rallying and support for the company by its clientele, by its customers. When we were appointed, because it was the first one in South Australia, it got a little bit of press coverage, but that had the effect of more people actually visiting the restaurant and supporting it to help it keep going and trade back in profitability. So I think. You're right, it probably does change the sentiment about the insolvency process. It's all about trying to give the company a second chance and rehabilitate its financial position. So in our case, it certainly did work, and I can't see any reason why it wouldn't work for other companies too.
So if we could make a change to the regime to help it work better and to help small business, is there anything, Nick, that you'd suggest that we look at?
Yeah, I mean, it is disappointing that the related parties don't get a vote. If they were given a vote, then I think there might be a few that would look at this rather than a voluntary administration and deed of company arrangement, because it is a bit unfair that they don't get a say in what happens with the proposal. And also just in terms of the the uncertainty on the reporting requirements of the restructuring practitioner. As I mentioned, the ATO has got an expectation as what should be provided, but that's more than what the minimum required under the regulations are. And if there was a bit more certainty about that, in terms of if that was provided for in the regulations, then it would be easier for the process to run smoothly without having to do the same large-scale investigations that you would get normally in a voluntary administration.
Yeah, and that I've just recently submitted my PhD, where one of the things I looked at was small business restructuring and the new regime, and that was one of the things that I recommended, some more regulatory guidance about what needs to go into the role of the restructuring practitioner, because
yes,
uncertainty equals cost.
Yes, exactly.
So, if we want this to be a streamlined procedure, if we want it to actually be cheaper than voluntary administration, then we need to accept that not everything that happens in voluntary administration is going to happen in this procedure. And so, in my experience, insolvency practitioners are often fairly conservative, particularly around personal risk, as they should be.
Yes.
So, they're going to really make sure that everything is thorough. So if we can have some regulatory guidance from ASIC around what its expectations are for reporting and investigation and those types of things, I think that would be helpful. Eddie, you've already mentioned the ATO lodgements as a practical hurdle. Is there anything else about this procedure that you'd change if you could?
To me, I think it was they dumped too much of the regulation from 5.3a into 5.3b. And I know you've personally got your own feelings about this, Jason, but especially around the ipso facto debacle. So it's unnecessary. It's overly complex. Yeah. And then I think they missed a big opportunity where instead of having, if you do have a trading, you have one of these that runs for 1 to 3 years. There should be an opportunity for you to include assets and include entitlements.
Yeah,
in my opinion, CVA style. And I think there was they've missed a huge opportunity there, because that's going to drive the cost up for someone like Nick. If someone's phoning up, saying, "Oh, can I sell this vehicle? Can I sell this desk? Is it in the ordinary course of business?" Well, no. So he's got to pick the phone, ask Nick every single time. Maybe it's more suitable, I suppose, for a COVID world where they're talking about they use the word pivoting. So yeah, maybe it's more suitable. But I personally think that they should have brought in the employee entitlements at the higher level, given them priority status, and also allowed the sale of assets. I think that was a big one to miss.
Yep, I can
personal views.
Agree. Yep, totally agree. So we've just gone over the 7 o'clock, so we might just draw it to an end there. We've had some great questions online. It's been fantastic hearing about the first experience in South Australia, Nick. So thanks very much for giving up your time, and also thanks to you, Eddie. As always, you've been a great supporter of this webinar series. So thanks very much for sharing your views. I'm sure we could probably all sit here and spend a couple of hours talking about what we would like the procedure to do in an ideal world. I'm not sure that the treasure is on the line, but if we keep talking about it, if we keep sharing our experiences and our views, then hopefully at some point, we can reach the people who make these decisions. And at some point we need to. I've said this on many of these webinars, but we keep adding to the regime. The Corporations Act keeps getting thicker and thicker. At some point, I do think we need to sit down and have a holistic look at the system rather than just adding new pieces, because new regimes create new uncertainties and new costs, and even if they also create new opportunities. And it's great. I've been quite negative about this regime. I think it's a missed opportunity. And I'm concerned that it could be a white elephant in our statute book, given the low numbers of appointments in the first year. So it's been great for me to hear, really a success story from Part 5.3b. So thanks, Nick, and also thanks, Eddie, and thanks to everyone for giving up your time for joining the discussion tonight. So as I said, we'll distribute a copy of the recording on our website, and we'll be sending an email to everyone who's registered. So look out for that. Aside from that, thanks everyone. Enjoy the rest of your evening. Thanks, guys.
Very good. Thank you all. Thank you. Thank you.
Thank you. Bye-bye.